Do you have any children?
Yes, ma'am.
What are their ages?
4, 3, 2, 1, 6 months.
And where are they? Who are they with?
Their mothers.
How many mothers?
3.
All right, that is not Black excellence. The fact that you're here is not Black excellence, unless that's the name of a building, but I'm assuming it's not. So you are not showing Black excellence to your ancestors or to your mother, your grandmother, or anyone. You understand?
Yes, ma'am.
So don't wear Black excellence if you're not showing it.
Yes, ma'am.
All right, is there anything else you need from the court to have Black excellence in your life?
Ma'am.
Today we're in Judge Boyd's courtroom, and we've got a defendant who thinks the court is a comedy show. This man rolled in like it's open mic night, laughing, dressed like he's headed to brunch, not a hearing. No respect for the process, no respect for the judge, and definitely no respect for himself. The man's wearing a Black Excellence t-shirt while standing trial for robbery. The irony's not just thick, it's practically choking the air in the courtroom. You'd think someone facing 20 years behind bars might take things a little more seriously, but not this guy. He's about to find out the hard way what happens when you treat the court like a joke instead of a warning. So is this confidence or complete delusion? Let's dive in and watch.
Nicholas Cornelius. And then after that, it will be Griselda Rosales. All right, who is the prosecutor on this case? Court is calling 2021 CR 0835, State of Texas versus Nicholas Cornelius. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas. And Jackson Lindsay on behalf of Mr. Cornelius, Judge.
Are you Mr. Cornelius?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client? Court will find that the state is in compliance with discovery. Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
As Judge, we're going with the lesser included offense of robbery.
Any objection?
No.
Showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with or at least the state is proceeding on the lesser included offense of robbery? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Did you understand if the court were to accept your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Judge. I believe he's competent.
Do you believe he's currently, yes. Do you believe he was legally sane at the time of the offense? According to the plea, the state is proceeding on the lesser included offense of robbery, and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions? Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation and no contact with Jose Aguilar. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the lesser included offense of robbery, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offer 6, exhibit 1 and all offense. No objection.
All right. And state, have you been in contact with the complainant?
So we have been in contact with the complainant, Your Honor. There were other co-defendants in this case. One of them also did have the charge reduced to robbery and was given deferred.
All right, thank you.
Buddy came into court wearing a Black Excellence t-shirt, and I'm confused because what part of being charged with robbery screams excellence? Maybe I'm missing something. Maybe excellence now includes criminal charges and court-ordered appearances. But seriously, it's wild how many people walk into a courtroom thinking it's a casual hangout, like they're just meeting friends instead of facing felony charges. The judge's face says it all. She was baffled like, this is what you wore to court? Then the conversation takes a wild turn when they start talking about deferred adjudication for robbery. That's like saying, hey, if you don't manage to rob successfully the first time, we'll just hit pause and give you another go. It's baffling the whole idea of deferred adjudication is meant for first-time low-risk offenders, not people who are out here snatching purses and calling it a life lesson. But hey, the system works in mysterious ways. Maybe this guy's teacher gave him some visible points in the courtroom fashion category because somehow he's still walking out without handcuffs, at least for now.
Oh, you may be excused to continue to confer. Mr. Cornelius, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, can we go off the record? Can I see the prosecutor? All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Judge, we're waiving guilt by.
All right, anything you wish to say on behalf of your client?
Just so the court is aware, Judge.
All right, so everyone, please whisper in the box. We're on the record. Yes.
Thank you, Judge. Briefly, my client had court in the Winston District Court back on May 31st of 2022. That day, he was arrested by the U.S. Marshals for a federal charge of being a person under indictment in possession of firearms.
Okay.
He spent 15 months in custody awaiting that charge. We worked out a deal in federal court for a plea bargain, accepting his ability to appeal that sentence because that particular statute is being challenged in the upper courts right now, 922N. 18 USC 922N. So because he was denied bond, he was in a position where he ultimately pled guilty because he did have the firearms. That explains why we took so long to come back to this court. He's here now, Judge. He's been offered deferred adjudication from the state. He's accepted it pursuant to the court's approval. As part of this federal judgment, after serving 15 months, he was placed on supervised release for 3 years, which I'm asking the court to run that concurrent with this federal case. And that in the event, unlikely event, I believe, he would be picked up on a violation of probation in this court, that any time served in federal court awaiting disposition of that case be credited towards any time given in that case, in the event he's sentenced.
All right. Do you have any children?
Yes, ma'am.
What are their ages?
4, 3, 2, 1, 6 months.
And where are they? Who are they with?
Their mothers.
How many mothers?
3.
All right, that is not Black excellence. The fact that you're here is not Black excellence, unless that's the name of a building, but I'm assuming it's not. So you are not showing Black excellence to your ancestors or to your mother, your grandmother, or anyone. You understand?
Yes, ma'am.
So don't wear Black excellence if you're not showing it.
Yes, ma'am.
All right, are you employed?
Yes, ma'am.
What do you do?
Pack and moving, Apple moving service.
Okay. All right, this is what the court is going to do. Court will sentence you to 3 years deferred adjudication. There's to be no contact with Jose Aguilar. There's to be restitution, if any, to FedEx. Regular reporting.
And if you thought it couldn't get any worse, turns out this isn't his only case. He's juggling a federal case on top of this one. Like the legal system's his personal subscription plan, 1 case per month, no refunds. The plea deal was deferred adjudication again, and at this point, I'm wondering how many second chances one person can get before the system finally says enough. He's got that smirk, that too cool to care posture, bragging about having 3 baby mamas like it's some kind of trophy collection. Judge Boyd wasn't having it. She calls him out right away, saying that's not Black excellence, and you can feel the tone shift instantly. For a second, it seemed like he might get it, but nope. He keeps laughing, looking around like he's performing for an audience, and somehow, by a miracle, he still walks out with 3 years of deferred adjudication, which is unreal. 3 years for someone who has 2 cases and 0 self-awareness. You can't make this stuff up.
By Zoom or in person, regular UAs, 200 hours of community service restitution. There's going to be parenting classes. Once he completes parenting classes, that will be deemed to be satisfied. Field visits, 1 time per month for 3 months, and probation. If you all want to check with the federal government and see how their field visits are, you may not have to do any if they're doing them as well. So if you could check with them. There's to be no contact with Aubrey Reed, Aubrey, Reed, Charlie James Ray Perkins, Amari Emari, Lafel Lafel, Freeman Freeman. There's to be proof of employment within 30 days, no employment as a home health care provider or with minors. Probation, is there anything else he needs?
Your Honor, the bill will say one time or just for 3 months.
Yes.
Your Honor, that's-
All right, is there anything else you need from the court to have black excellence in your life?
I'm out.
Judge, maybe run this concurrent with this federal cause number. I can give you that cause number.
All right, concurrent with, what's the number?
SA:22-CR-294.
All right, the court will run it concurrent.
Thank you, Judge.
Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. You understand?
Yes, ma'am.
All right. Is there anything else you need from the court to be successful?
I'm out.
All right, we can go off the record. Here's the thing. From here on out, in this court, whatever you do in your life while you're on probation, you need to ask yourself 2 questions. One, is what I'm doing something that could potentially result in me being revoked and sentenced to prison for 20 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. Do you understand?
Yes, ma'am.
All right, good luck to you.
You can literally see it on the man's face. He's ready to get out of the courtroom. Bored, slouched, eyes drifting everywhere but the judge. He's acting like he got dragged into jury duty he didn't sign up for, not a hearing that could change his entire life. He's rocking that smirk, swinging his head back and forth like the judge's words are background noise. It's not confidence, it's detachment, and that's the dangerous part, because once you stop taking court seriously, it's not a matter of if you'll be back, it's when. Watching him, you can almost see the next arrest playing out already, like he's mentally mapping out his next mistake. Judges see hundreds of cases like this, people who think deferred adjudication is a free pass instead of a final warning. So what do you think? Should judges be more lenient with repeat offenders, or are we just setting them up to fail again? Thanks for watching, like and subscribe, and take care.